Spouses Restituto Nonato and Esther Nonato, petitioners, versus the Honorable Intermediate Appellate Court, and Investors Finance Corporation, respondents, GR number L-67181, November 22, 1985. Rule synopsis. The remedies provided for under Article 1484 of the Civil Code to a seller of a personal property in installments where the buyer defaulted in at least 2 installments is alternative, not cumulative. The facts of the case are: on June 28, 1976, defendant spouses Restituto Nonato and Esther Nonato purchased 1 unit of Volkswagen Sakbayan from the People's Car Incorporated on installment basis. To secure complete payment, the defendant executed a promissory note and a chattel mortgage in favor of People's Car Incorporated. People's Car Incorporated assigned its right and interest over the note and mortgage in favor of the plaintiff Investors Finance Corporation. For failure of defendants to pay 2 or more installments despite demands, the car was repossessed by plaintiff on March 20, 1978. Despite the repossession, plaintiff demanded from defendants that they pay the balance of price of the car. Finally, on June 9, 1978, plaintiff filed before the Court of First Instance of Negros Occidental the present complaint against defendants for the latter to pay the balance of the price of the car, which damages attorney's fee. Issue of the case. May a vendor or his assignee who had cancelled the sale of a motor vehicle for failure of the buyer to pay 2 or more stipulated installments also demand payment of the balance of the purchase price? Spouses Nonato purchased a car from People's Car Incorporated, predecessor of Investors Finance Corporation, or IFC, on installment basis. The spouses executed a promissory note for its payment. They also constituted a chattel mortgage over the car. Spouses Nonato then failed to pay at least 2 installments. Investors Finance Corporation repossessed the car and also demanded for payment of the balance. The spouses refused. Held no. The remedies provided for under Article 1484 have been recognized as alternative, not cumulative, that the exercise of one would bar the exercise of another. While IFC denies having exercised its right to cancel the sale of the repossessed car, the court held that its acts are wholly consistent with the conclusion that it had opted to cancel the contract of sale of the vehicle. The applicable law in the case at bar involving, as it does a sale personal property on installment, is Article 1484 of the Civil Code, which provides, in a contract of sale of personal property, the price of which is payable in installment, the vendor may exercise any of the following remedies. 1. Exact fulfillment of the obligation should the vendee fail to pay. 2. Cancel the sale Should the vendee's failure to pay cover two or more installments? 3. Foreclose the chattel mortgage on the thing sold if one has been constituted. Should the vendee failure to pay cover two or more installments? In this case, he shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. After due hearing, the trial court rendered a decision in favor of the IFC and against the NONATOs, as follows. Premise considered, the court hereby renders judgment ordering the defendant to pay the plaintiff of the amount of 17,537 pesos and 60 centavos with interest at the rate of 14% per annum from July 28, 1976 until fully paid. 10% of the amount due as attorney's fee, litigation expenses in the amount of 133 pesos and 5 centavos plus the cost of this suit. No pronouncement as to other charges and damages. The same not having been proven to the satisfaction of the court.